Hello friends, in today's session we are going to discuss the case Grid Corporation of Orissa Ltd versus Indian Charge Chrome Ltd. First, let us understand this case briefly. This case pertains to Section 11 of Arbitration and Conciliation Act and involves a dispute between Grid Corporation of Orissa Ltd, GRIDCO, and Indian Charge Chrome Ltd, ICCL. GRIDCO demanded a payment of rupees 24.8281 crore from ICCL. When ICCL failed to make the payment, GRIDCO warned of cutting off electricity supply. ICCL approached the Regulatory Commission for a resolution, but since the dispute remained unresolved, it filed an application before the High Court seeking the appointment of an arbitrator. The High Court appointed an arbitrator and directed that electricity supply should continue. However, the Supreme Court ruled that unless the Regulatory Commission first refuses to appoint an arbitrator, the High Court cannot directly appoint one. Furthermore, it was held that financial difficulties alone cannot be a valid ground to stay the disconnection of electricity supply. Now, let us study this case in detail. Answer: Appellant Grid Corporation of Orissa Ltd versus Respondent Indian Charge Chrome Ltd. Reference 1998 5 SCC 124. Subject matter: the case is based on Section 11 of the Arbitration and Conciliation Act. The primary issue in this case was whether the appointment of an arbitrator would be valid if the Regulatory Commission failed to mediate the dispute. The court ruled that in such cases, the appointment of an arbitrator would be invalid and the petition would not be maintained. Facts of the case: the Grid Corporation of India (GRIDCO) became the successor of the Odisha State Electricity Board (OSEB) on April 1, 1996, with the responsibility of distributing and supplying electricity to consumers in Odisha. Indian Metals Ferro Alloys Ltd (IMFA) and Metals Indian Charge Chrome Ltd (ICCL) were part of the same corporate group. In 1984, ICCL sought government permission for self-electricity production, and in 1989, it established a captive power plant in Choudwar, Odisha. The electricity generated from this plant was primarily supplied to IMFA located in Choudwar, while the surplus electricity was sold to Orissa State Electricity Board. For administrative convenience, ICCL was established and OSEB entered into an agreement with ICCL. According to this agreement, OSEB was to supply power through ICCL to ensure that IMFA's Charge Chrome production unit received uninterrupted electricity. This arrangement was in effect until November 15, 1994 and was renewed on March 4, 1995. As per the revised agreement, the electricity supply rates was set at 77 paisa per unit with an additional energy charge of 15 paisa per unit. ICCL was also allowed to draw power at the rate of rupees 2.31 per unit. This agreement was valid for 6 months. GRIDCO demanded a payment of rupees 24.8281 crore from ICCL for electricity supplied between December 1994 and December 1996. However, ICCL was unable to make the payment. Consequently, On February 25, 1997, ICCL filed a petition before the Orissa Electricity Regulatory Commission under the Odisha Electricity Reform Act, challenging GRIDCO's demand and seeking a review of the matter. On April 8, 1997, ICCL submitted another application to the Regulatory Commission, but the dispute remained unresolved. Subsequently, on April 24, 1997, GRIDCO issued a notice under Section 24 of the Indian Electricity Act, warning ICCL that if the outstanding amount was not paid within 7 days, the electricity supply to ICCL and its associated establishment would be discontinued. ICCL failed to make the payment within the stipulated period. On April 30, 1997, ICCL filed a petition under Section 9 of the Arbitration and Conciliation Act seeking an interim injunction to prevent GRIDCO from disrupting its power supply. The district judge granted the injunction. GRIDCO challenged this order before the Odisha High Court. The High Court stayed the implementation of the district judge's injunction. Subsequently, ICCL filed a petition seeking withdrawal of the order. The High Court ruled that electricity supply would be restored only if ICCL made a payment of at least Rs 5 crore. ICCL challenged this order in the Supreme Court, which allowed the amount to be deposited in 2 installments. Meanwhile, on May 25, 1997, the Regulatory Commission directed ICCL to clarify its status since it was not a licensee under the Electricity Reform Act. Therefore, its application should be treated as a reference under Section 37 of the Act. GRIDCO objected to this High Court proceedings. On July 14, 1999, ICCL filed an application before the Odisha High Court under Section 11 of the Arbitration and Conciliation Act seeking the appointment of an arbitrator. During this period, the additional district judge issued an injunction against GRIDCO based on 2 separate applications filed by ICCL. GRIDCO challenged these injunctions before the Odisha High Court. Additionally, GRIDCO issued a notice to ICCL to disconnect power supply for outstanding dues of Rs 13.1888 crore for the period from June 1997 to September 1997. ICCL challenged this notice in the High Court, which granted interim relief on November 11, 1997. On February 10, 1998, the Odisha High Court dismissed GRIDCO's appeals and ICCL's petitions together, ruling that the dispute could be resolved through arbitration under Section 37 of the Odisha Electricity Reforms Act and Section 3 of the Electricity Act. The High Court appointed a retired Chief Justice as an arbitrator and ordered that ICCL and its associated units should continue receiving electricity supply. Dissatisfied with this decision, GRIDCO filed an appeal before the Supreme Court on February 10, 1998. Supreme Court judgment. On May 13, 1998, a Supreme Court bench comprising Justice G.T. Nanavati and Justice S.P. Kurdukar delivered the following judgment after hearing arguments from both sides. ICCL had not submitted an application for the appointment of an arbitrator before the regulatory authority. The High Court erred in assuming that the application was for arbitration and in concluding that the regulatory authority had failed to appoint an arbitrator. Therefore, the petition was premature. Although ICCL had the authority to supply electricity, it was not a licensee under the Electricity Act and the Odisha Reforms Act. Hence, treating it as a licensee and allowing arbitration under Section 37 read with Section 33 of the Electricity Act was incorrect. The appointment of an arbitrator should have been done by the regulatory authority. Moreover, the order to stay proceedings based on a notice issued under Section 24 of the Electricity Act was unjustified. Proceedings cannot be stayed solely on the ground that the debtor is facing financial difficulties. Instead, installment payments should have been determined. Legal principle established. First, until an application for the appointment of an arbitrator is submitted before a competent authority and rejected by that authority, the High Court cannot appoint an arbitrator under Section 11 of the Arbitration and Conciliation Act. 2. Before granting an interim injunction under Order 39, Rule 1 and Rule 2 of the Civil Procedure Code, the balance of convenience must be properly assessed. Please watch full video, share and subscribe to the channel.